Hello, brother.
Morning, Mr. White.
Hello, Your Honor.
How's jail? Shh. How's jail? Good. The worse a jail visit is, the higher likelihood you have of actually considering when a judge tells you to do something that you will actually do it, right? You, my friend, have been on the lam for 24 years.
Sir.
20. I don't think we've ever had someone with that kind of just.
No, this is a record.
I don't want the record. I don't want it. But this was also unusual because they had a misidentification of an FBI number. So it's 2 for 2.
But he's got to know at some point you can't just continue to run. That, you know, the long arm of the law is at some point.
At some point, yes.
Itch it, right?
Absolutely. But as I said, Your Honor, he's here. He's got his family here. His son is here. He has 4 kids, and he's working. And I've told him that he must go to Wisconsin, and they're going to hire an attorney up there. I bet you a dime to a dollar.
Why haven't they hired a lawyer already?
I have an attorney.
My question, and
I
to
do
try
have
to
an
figure
attorney.
out.
Well, I mean, Your Honor, I don't know. You remember practicing law.
Sure.
Sometimes they just put their head in the sand.
And I guess at that point, the counsel is to be proactive
Yeah.
because you know that.
Right.
So Dave, what do you think?
Well, just
I have a hard time giving someone a bond that's been on the land for 24 years. I'm going to say that now. I really do, Mike. As much as I love you and appreciate you and your tenacity.
Yes, sir. And I'm going to be tenacious because 24 years, he was here 4 years ago. They took him into custody on the terroristic threat, a misdemeanor. And it's done. I mean, and I understand he's still here. And so I hear what you're saying. I just know that if you're taking care of your kids, if you're living in the same place for a period of time, I think that he's going to take care.
Imagine being wanted for 24 years and then finally standing in front of a judge asking for bond. That is exactly where this courtroom drama begins. The court is dealing with a defendant who has apparently spent decades avoiding the consequences of an old case. And now, after all this time, his attorney is asking the judge to give him another chance. But the judge immediately has a problem with that request. The court points out that bond conditions exist for a reason. If someone has already spent 24 years failing to deal with their legal situation, why should the judge suddenly trust that person to follow through now? The defense argues that he has a family, children, and responsibilities. They insist that he will take care of his business if he's given some time. But the judge isn't convinced, because after 24 years, promises don't carry nearly as much weight as actions.
His business. The purpose of bail is to ensure his appearance in court and to secure his appearance up there. If we leave him in jail here, and that's the alternative.
Well, it's not leaving him. It's just we are now going to ensure that Wisconsin gets their man.
No,
because
we're ensuring that he's available for Wisconsin to get him. We don't know if Wisconsin's going to come.
they're gonna.
Say it again.
They confirmed the warrant flag. They're intending on coming unless they change their mind in the last 24 hours.
Right.
Continuous office does want it, Judge.
Yeah, I mean, everybody says that.
I can't imagine after 24 years, they're going to say, you know what, just forget it.
Well, I can't imagine prosecuting a delinquency of a child.
Well, one of the cases is a robbery.
Yeah, but we don't know the extent of it. It's not aggravated.
That's
right. We don't know.
That's not what we fight here.
No, I understand. I just think he should be entitled to a bond. He's going to take care of his business. He goes and takes care of it now. You give him 2 weeks.
I promise,
Mike.
Judge.
I'm sorry?
I promise.
Yeah, you promised before
When he was 18.
when you were 17. And then, you know, the thing is Mr. White, don't try to throw other people under the bus. That's not cool. It's all on you. And for you to try to blame it on anyone else is just disingenuous, man. The case, it's 24 years. You've had 365 days for over 20.
The judge's concern becomes even clearer as the discussion continues. The defense keeps arguing that the defendant deserves bond and that he will cooperate with Wisconsin. But the court is looking at the history instead of the promises being made today. The judge basically asks, if you were serious about fixing this situation, why didn't you do it years ago? The defendant's side explains that Wisconsin is expected to come get him and that an attorney has supposedly been working on the case. But the judge isn't interested in another story about what might happen. The court wants action. And then comes one of the strongest moments of the hearing. The judge tells the defendant not to throw other people under the bus. After all, this is his responsibility. He has had years to deal with it, and blaming other people isn't going to erase that history. 24 years is a long time to keep something hanging over your head. And the judge is clearly running out of patience.
24 years, you've had that in the little back of your mind thinking, God, out of sight, out of mind doesn't work with the law.
I've actually hired an attorney prior to this in Milwaukee, Wisconsin. He was working on a deal with the district attorney's office there. Okay. I hired him. He's been hired under $5,000. I paid him to contact to work a deal with district attorney's office and told me he was working a deal with them.
What's his name?
Hold on. Is my son here?
Yeah.
He knows, no, he knows his name. I have his number.
It's irrelevant. It doesn't matter. The name, just what matters is action. You telling me something is going to go in there, go out that ear, because I know that you've done this before and you've never followed up. I can't in good conscience give you a bond, man. It's 24 years.
My son, I have a 2-year-old son. And he's going to Texas Children's. He has a genetic disorder. I can't leave here because his life depends on it. He has a rare genetic mutation. His name is Mariano. He has a rare genetic mutation, and his condition is life or death. I've sought the best doctors in the country for him. I came here for him to treat my baby. His name is Mariano. His doctor is Gary Clark, neurologist at Texas Children's.
That's ironic. Gary Clark is my running buddy for 30 years. He'll be back from San Diego next week.
And I know Gary Clark.
I understand. And the good thing that you have.
Then the defendant brings up something much more emotional. He explains that he has a young son with a serious medical condition and says he came to Texas because his child needs treatment. He talks about doctors, his son's condition, and how important it is for him to be there for his family. For a moment, the situation becomes extremely personal, but the judge makes something very clear. The court understands that the defendant loves his family. The judge even acknowledges that he has people willing to help him. But that doesn't change the fact that he has been dealing with this legal problem for 24 years. The judge refuses to let the child situation become a reason to ignore the defendant's history. The court then discusses whether he will waive extradition and how long the process could take. And finally, the message becomes crystal clear. The judge is not setting bond. The family is told that there are only limited options left, and they will have to come back again. After 24 years, the defendant's last-minute promises simply aren't enough.
It's just for the baby, sir. I don't care about myself.
Thankfully that you have a loving sister and you have a loving son that are willing to help you out so that baby's not getting thrown under the bus. But I'm not going to allow you to sit here and use your baby as a means of trying to get a bond when you've been on the land for 24 years. I'm just not going to do it.
I'm just telling you a story.
May it please the court?
Sure.
Based on what I see, how the tea leaves look like they're rolling, maybe we come back here in 15 days. Because I don't think he's going to sign. He may sign the waiver.
Oh, he's going to refuse?
Well,
I mean, if so, let us know now so we can get the governor's warrant, because the thing is then there's going to be another 90 days.
no, I understand that.
You
I'd
know?
like to have a short period of time to talk to him about whether he
Sure.
wants to waive.
Of course, he hasn't waived yet.
No, he's refused.
Okay,
Oh,
you
can we-
got to understand that.
Can we carry him till tomorrow? Okay.
I mean, there's no, but
I mean, I know, I can tell the family now, the judge is not going to set the bond. You have two options.
I love you, Mike. I really do. But 24 years, that's unreasonable.
It's pretty impressive.
For me to be able to just, it's
No, I got it. We'll see you tomorrow.
okay.
It's a pleasure. Right, see you tomorrow, bye-bye. All right. You have to go again?
What is the one thing I ordered you not to do? And why are you here? So one of two things is evident. Either you don't care about bond conditions, you don't care what judges say, or you have a problem. But, we ordered you not to use. It's a serious case. It's a DWI second offense, and you're using.
Your Honor, I don't blame myself, but I know after we left court.
How is it possibly your fault?
Well, Your Honor, it's because typically what I do with my clients, I emphasize to them the bond conditions and I reiterate how important they are to follow them.
I emphasized on her ad nauseam.
And just when you think the hearing is over, the courtroom suddenly moves to a completely different case. This time, the judge is dealing with a defendant accused of violating his bond conditions in a serious second DWI case. The judge asks one simple question. What was the one thing I ordered you not to do? And the answer is obvious. The defendant was ordered not to use alcohol. Yet he's back in court after allegedly violating that condition. His attorney tries to explain what happened and even apologizes. But the judge has heard apologies before. And that's when the judge makes the point very clear. Bond conditions aren't suggestions. They're orders. If the court tells someone not to drink, the expectation is simple. Don't drink. Because when someone violates those conditions, the court has to reconsider whether releasing that person is safe. And the judge decides that things are about to get much stricter.
When she was here last time.
I sincerely.
Stephen. Sorry?
I apologize. I know.
If you kill someone on the side of the road, do you think that apology does anything? If I had one strand of hair for every single person that told me sorry in here, holy moly, I would look like Gene Simmons. But no, bond conditions are in there for a reason, right? And when you fail to live up to them, there's one thing that happens. She goes with you. Come talk with me back. Alex, I'm now putting a monitor on your ankle so I know that you're not using at any time at all times. You will now get a scram device on one ankle so I know that you're not using on your other ankle. I'm going to put a GPS monitor and I'm now giving you a curfew. You are not allowed to be out in the middle of the night. Do you understand? And if you ever test positive again, your bond will be so high that it's going to reach the clouds. Do you understand? You will be taking the Dodge patas everywhere. No more driving as well. Do you understand?
I can't go to work.
I didn't say you couldn't go to work. You're on a very serious second DWI and you're continuing to consume. I want to do everything in my power to protect the public. I don't want you on the street and I don't want you out in the middle of the night. You're continuing to use. It scares me. Do you know every single day someone dies from an alcohol-related collision in this county? Every single day. And I will do everything in my power to prevent it from happening. I'm modifying your conditions now in lieu of taking you into custody. You can sure do it the other way around. You know, Joaquin.
Yes, sir.
We can always reapproach with conditions at a later time. But I want to
Yes,
know that my Houston is protected because that's the only thing that matters to me. Do you understand?
Yes.
There
Yes,
are
sir.
other ways and you need to be able to find it. But I can't trust you in the car if you're continuing to use when we ask you not to use. I will give you a curfew of 10 p.m. to 6 in the morning. You're not allowed to be out past 10 p.m. If you violate curfew, if you consume alcohol again, then I will lock you up and I'm not going to play this game with you again. You understand? Okay. All right, just take a seat for me. We'll be back with you here shortly.
The judge now completely changes the defendant's bond conditions. First comes an alcohol monitoring device, then a GPS monitor, then a strict curfew. And the judge makes it clear that another positive alcohol test could send the bond amount through the roof. The defendant also loses the ability to simply drive around as before. The judge explains that this isn't about punishment for the sake of punishment. It's about public safety. The court is worried because this is a second DWI case, and the defendant is allegedly continuing to consume alcohol despite being ordered not to. So the judge gives him one more chance, but this time, there is almost no room for mistakes. The curfew is set from 10 p.m. until 6 a.m. No alcohol. No violating the conditions. And the warning is unmistakable. If he violates the curfew or consumes alcohol again, the judge says he'll be locked up. At this point, the message couldn't be clearer. The court gave him freedom with conditions. He broke those conditions. And now that freedom comes with a much tighter leash.